Welcome to the video lecture series of Project Development and Resource Management. Course code MC301, contact hour 4 per week, credit 4. Lecture 9. This is MTech third semester course. Myself, Dr. Shunipara, Head of the Department, Electronics and Communication Engineering, Guru Nanak Institute of Technology. So this is module 2. Module 2 actually dedicated for intellectual property right. In this module 2, today we will discuss actually what is intellectual property, importance of property, type of patents, patentable invention, who can apply and all. So this is the content, that is first start with introduction, that is intellectual property, IPR offices in India, what is an invention, what is patent, history of patent, types of patents, what can be patented, what cannot be patented, stages to obtain a patent, beneficiaries of patent grant, what rights do patent bring, patent information, importance of patent information, contents of patent document, limitations of patent, conclusion and references. So these are the intellectual property rights as already discussed in earlier lecture, that is patents, design, trademark, copyright, geographical indicators, in short GI, all are the intellectual property right. And what is patent, what is design, what is trademark, what is copyright, what is geographical indicators, that has been elaborated already. So moving to our next slide. Actually, what is meant by invention? Invention is nothing but any new or useful product. Any process or method can also be termed as invention. A machine or an apparatus can be termed as invention if you invent a new machine or a new apparatus. If you also plan an article of manufacture, that is also called invention. Improvements of any of the above, that is any revision, any modification, can also be termed as invention. Invention not necessarily always a completely new product. It may be revision, modification of the existing product, that also can also be termed as invention. So the word patent originates from la patere, which means that open, that is to make available for public inspection. That is actually the term patent mean. So in modern usage, the term patent usually refers to the right granted to anyone who invents any new, useful and non-obvious process. The term non-obvious is very, very important. This non-obvious process, machine, article of manufacture or composition of matter. Some other types of intellectual property rights are also called patents in some jurisdictions. Industrial design rights are also called design patents. In the US, plant breeders' rights are sometimes called plant patents. A patent is an exclusive monopoly grant by the government of an inventor over his invention for a limited period of time. It is for the period of 15 years. So, if we go through the history of patent, then we find that in 1856, the Act of 1856 on Protection of Invention was first documented. In 1911, Indian Patents and Design Act has been formulated. In 1970, Patents Act only process patents, that is 14 years and 7 years, depending on whether it is a product or food or drug that has been invented or documented. In 1999, India signed TRIPS, process and product patent in all fields. We will study what is TRIPS later on. In 2002, 2004, amendments for the efficacy of the Act has been documented, and in 2005, Indian Patent Act, that is process and product patent for 20 years patent period, has been documented and finalized, and the act was passed through the concerned authority. So there are 4 types of patent, that is utility patent, design patent, planned patent, and reissue patent. So utility patents actually may be granted to anyone who has who created or discovers any new and useful process, machine, article of manufacture, or composition of matter, or any new and useful improvement. So utility patent particularly dedicated for a product, that is for the common people use, and design patents is nothing but may be granted to anyone who sets a new, original, and ornamental design for an article of manufacture. That I have already told you that the car design, each company file the patent for each and every car, and then they commercialize the product. So this is called design patents. Then planned patents actually okay, come to the point. Utility patents may be granted to anyone who has discovered any new and useful process that is particularly applicable for product, Design patent may be granted to anyone who has new, original and ornamental design for an article of manufacture. And plant patent says may be granted to anyone who has discovered and reproduces any distinct and new variety of patent. So the new variety of plant. So that is particularly dedicated for agriculture or pharmacy field. And reissue patent. Reissue patent is nothing but if there is an error. Say you have applied, filed a patent, and you found that there is an error that is to be revised or that is to be corrected. Then you have to reissue that patent. So when you find an error in a patent proposal, then you have to reissue, you have to correct the error and have to reissue the patent. There is a provision in the available in the government. So what can be patented? Any invention which must be novel, non-obvious. That means there is no actually this obvious means this cannot be changed. There is no such idea. This is non-obvious. That means some changes, some modification always is possible. So that is the novel, non-obvious, capable of industrial application, and must not be declared as non-patentable under the Patent Act. So what cannot be patented? Any artistic creation. Say you are a good artist and draw a picture, but that cannot be patented. Any mathematical method that cannot be patented. Business schemes cannot be patented. Anything against universal law that cannot be patented. That should be by law. So stages to obtain a patent, there are different stages are there. So after having this lecture, you will be able to know how to file a patent and what is examination and all that. So filling an application for patent, that is, application is required to be filed according to the territorial limits where the applicant or the first mentioned applicant in case of joint applicants for a patent normally resides and has domicile and has a place of business or the place from where the invention actually originated. So first there is a patent form. You first fill up the form, and 4 patent offices are there located at Kolkata, Mumbai, Delhi, Chennai. Wherever your city, you please go to that particular office and apply for the patent after submitting the particular documents available in their website. And examination, that is, examination is nothing but the early request of exam that is also available. No application for patent will be examined if no request is made by the applicant. So when you file a patent, if you think that someone will see and go for the exam, go for examining your patent proposal, whether this is novel or already the work exists, that is not true. After filing patent, you have to apply for examination. Then only, if no request is made by the applicant or by any other interested person in Form 18 with prescribed fees of the 2,500 or 10,000 as per the GOI Government of India rule, and other natural person within a period of 48 months, if the person do not apply for examination, then the patent form becomes dormant and it kept aside. So after applying for examination, you will go for first examination report. You will get the first examination report stating the objections or requirements is communicated to the applicant according to the address for service actually whatever the objection or requirement objections are there when you apply for examination, you will get a reverse mail or reverse document that is called first examination report, where we will find various comments from the objectors who are creating the objection within a and you have to meet these objections, or you have to amend, or you have to revise your patent accordingly, or your product accordingly, or your document accordingly, and within a period of 1 month from the date of first examination report. And there is also a process of withdrawal. The application for patent can be withdrawn at least 3 months before the first publication. And the application withdrawn after the date of publication cannot be refiled, as it is already laid open for public inspection. This patent publication is done in patent journal uh, as per the government instruction, and there are patent website also, and that is available in the patent website. So next stage is grant of patent. So first stage is filing of patent, next is first examination report, the last stage is grant of patent. The patent is granted after 6 months from the date of publication under section 11A. Now opposition, there are two types of opposition. One is pre-grant opposition, another one is post-grant opposition. Term and date of patent. Term of every patent will be 20 years from the date of filing of patent application. Date of patent is the date on which the application for patent is filed. So, beneficiaries of patent grant. Patentee, right to use patented invention in several ways. To develop a business to prevent the copying during the term of patent, and allow others to use it as at a price mutually agreed, then sell it. Patentee has these rights. And if you go for society, newer, better and cheaper products available to the public as a database for further invention, freely available technology after expiry of patent. So that is the benefit of patent grant. What rights do patent bring? Actually, patent brings different types of rights. There are some positive rights and there are some negative rights also. A bargain between patentee and government. Patentee gets exclusive rights to his invention. Government gets rights to publish the full invention. And a negative right is also there. Patentee may exploit the invention by selling to other third party, that is maybe outside of nation, abroad, for having huge income. So that is called negative right. And patentee gets right to take legal action against the infringers. Infringers means those who are copying and expressing that this idea or invention is of their own. So patent information related to inventions disclosed in a patent document. Which information does the patent document provide? What is the technology field of invention? Which technical problem is solved and how? What is the prior art? Who is the inventor? And when and where the application for patent was applied, name and address of the inventor. All these, when filing the patent, there is a form, and that form contains all these points, and inventor has to fill up all these points, and then they have to apply for the patent. So the researcher and inventors in industry, R&D organization, university, to avoid duplication of research, they have to file patent. To find ready solution to technical problems in ongoing research, they have to file patent. And to keep up to date with developments in technology field, and industry person to improve existing technology, to increase production, to identify suitable technologies for adaptation, and for business enterprise to identify new products for marketing and to find out patent owners. This is the information of patent, and consultants and planners are also there to advise industry, R&D, financial institution on issues related to technology to find out a new technology for business. And contents of patent document. Patent documents actually consists of biological data. Biological data means a name, then application name, the address, and the number and dates, application number and date, patent number and date, title of invention, inventor's name, assignee's name, inventor's name and assignee's name. This may be different. Inventor's name maybe your name, but assignee's name, assignees is nothing but the where you are continuing your job, your company may be the assignee, but inventor may be you. Abstract of invention, you have to write the abstract of invention, you have to put the drawing if any there is, and complete details of invention you have to write. Number of claims by the patentee or inventor has to write different claims, that it may be 5 to 10 claims at least required to file a standard patent. So number of claims by the patentee, that is very important part. On the basis of that, when the first examination report, when the third party or public do the inspection, they particularly go through the claims part, and if it crosses the earlier claims, then the public or the those who are doing the inspection of patent or examination of patent, they put their comments, and that come to the patentee or the inventors in the form of objection. So kind and language of publication, and if there is any, because before filing a patent, publication can't be done, and after filing patent, I think after 1.5 years minimum required to publish that work in the journal. That is the restriction of publication of that particular work, what you have filed as a patent. So classification codes are there, international patent classification code and national classification code are there. That is actually under the jurisdiction of a particular patent office. And this is one of the example, whatever I am showing, you may go to the patent website that is available, Kolkata, Mumbai, Delhi, Madras, patent websites are there. You may go through that, and all the details you can get from that website. And there are some limitations. What are the limitations? What are the pros and cons? What are the ifs and buts? That all these things you can get, all these information you can get from the patent website. Now the limitations of patent is one, obviously cost, because it is costly. Costly, I mean, if you are manufacturing a product, then you have to invest the capital, and that is obviously costly. You have to invest some capital money, and then time is also, you have to devote some time also, and you have to wait for the patent to be published or granted. That grant minimum required 2 years from the time of publication, and that much time you have to wait, nothing to do other than wait. So you have to wait for that, and that much time you should spare from your lifetime. Loss of information may be sometimes, loss of information may be happen, though this is very unfortunate, still may be possible. infringers are there, they are getting copy the patent. And exploitation of invention, actually exploitation already mentioned that inventor may sell their invention to third party for the actually huge income. So that is the limitation of patent, and these all are the references. If you have any question, feel free to ask me. Thank you.